on moving day and the fact that it's fast approaching, and are you ready? There is a question and answer panel on the side for you to answer your questions, and if you pop those in at any time, I can respond to those as we go along. So thanks again for joining us for this webinar this morning, and as you're probably aware, we have a spread right across the country in terms of our offices, and you can see that on the map displayed on your screen. And on the left-hand side there is a list of the kinds of workplace law problems that we can assist you with if they arise for you. Today we're going to cover a number of issues as we gear up for the change in season in the dairy industry, and there's no better time than now to make sure that your workplace is up to speed. And when you're bringing on, or whether you're bringing on new team members or reviewing existing arrangements, having the right employees with the correct employment arrangements and policies in place is critical. So it's not just for compliance, but it's for creating a solid foundation for the year ahead. And I guess moving down than just a shift in location, it's a prime opportunity to ensure that you're meeting your employment obligations and protecting your business, your team and yourselves. So in this seminar, we'll be walking you through everything you need to know to start the season on the right foot. And topics we'll cover include things like employment agreements, what's required, what's recommended, and how to tailor them to your farm setup. We'll discuss service tenancy agreements, and that's when housing is part of the job, to make sure that you've got clear agreements to help you avoid future headaches. We'll talk about contractors and understanding the difference between an employee and a contractor and why that matters. And lastly, we'll talk about some minimum wage considerations and making sure that you pay people correctly and that practices are up to date and compliant. We'll break down the key obligations, answer your questions, and give you the confidence to head into the new season with the clarity and peace of mind that you know that you're doing everything correctly. At the end, we'll also cover off a few immigration matters. So with employment agreements, a lot of you, I suspect, will be having to enter into new employment agreements for new arrangements with people. And it's important to understand employees' minimum entitlements and to ensure compliance with key aspects like the minimum wage and KiwiSaver. So with your employment agreements, it's important that when employees are presented with a letter of offer, they have plenty of time to review the agreement and seek advice before their intended start date. And it's also important to understand that once an offer of employment is made and accepted, that person is considered to be an employee by law. So you can't simply withdraw an offer even if they've not started their employment. Employers at this stage of the process then need to consider what type of employee you're hiring and the most appropriate form of employment agreement to be used. So the point that someone has been offered and accepts employment, they are a person intending to work for the purposes of the Employment Relations Act and have all the rights and obligations of an employee. There are several types of employees, and they can be permanent, fixed term, or casual. And each type of employee comes with a different set of obligations, rights, and responsibilities. So employers need to ensure that you're getting it right from the start to save any problems down the track. And the problem, or at least the consequences of getting employment obligations wrong is pretty serious. And penalties can be imposed against non-compliant employers by the Employment Relations Authority, and they can be up to $50,000 for an individual and $100,000 for a company. There is also the ability for a labour inspector to issue an on-the-spot $1,000 infringement fee if an employer doesn't have an individual employment agreement. It's also really important that any letter of offer highlights any important clauses in your employment agreement. For example, a 90-day trial period. And there was a recent case of Farrand and Farrand Orchards Limited in Tane. And that was a case where an employee was offered a role, but the 90-day trial period was not highlighted to him in the letter of offer, and he commenced work before he signed the employment agreement. He was dismissed soon after his employment commenced, and that was in reliance on the 90-day trial period contained in his employment agreement. The case went to hearing, and the court held that the 90-day trial period had not been highlighted to him in the cover letter or email, and had that occurred, then his defence about the 90-day trial period would have been defeated. Unfortunately, though, because the company didn't do that, it had to pay an unjustified dismissal claim, and his case was successful. When we talk about different types of employment, there are three kind of key categories that we would refer to, and they are permanent, fixed term, and casual employees. And if you think about firstly permanent employees, that's the most common type of employment, and that type of employment continues indefinitely until terminated by either party. And a permanent employee can be either full-time or part-time. The key point is that for permanent employees, once the service extends beyond 6 months, then they are entitled to things like paid family violence leave, paid sick and bereavement leave, and once the employment extends beyond a 12-month period, they are entitled to 4 weeks paid annual leave. Contrast that with a fixed term employee, and that's where an employer might want to employ someone on a fixed term or temporary basis. But to do so means that you must have a genuine reason based on reasonable grounds for the fixed term employment. It cannot be to assess someone's suitability for future employment. If the employment is fixed term, then the employer has an obligation to record the reason for the fixed term in writing and within the employment agreement. And common reasons for a fixed term include things like for a calf rearing, perhaps to cover someone who's on parental leave, or if someone has suffered an injury that means that they will be away from work for a prolonged period, then fixed term appointments can be made. It's important to note that if a fixed term appointment is not for a genuine reason based on reasonable grounds, and an employer then attempts to terminate the employment, it will likely be held to be an unjustified dismissal because there was not genuine fixed term employment. An area that we see is commonly poorly handled is casual employment. Many people say that their employees are only casual, yet if you discuss the frequency with which those people work, largely it is week on week for full weeks, and that has continued for quite some time. That's not truly casual. To be truly casual, the employment must legitimately be on an as and when basis. The employment must be intermittent, and there must not be any certainty that the employee will be given regular or frequent hours of work, or that there's a regular pattern of work emerging. It should really only be used when the employee is needed just on an ad hoc basis, such as to cover perhaps someone who's sick and you need some cover for milking for the day. That would be an example. Another example might be if you wish to give the team the day off for Christmas Day and Boxing Day, for example. As I've said, there is serious risks associated with keeping long-standing employees on casual employment agreements, especially if you have been paying them pay-as-you-go holiday pay, because if that casual employment extends beyond 12 months, then the risk is that you will have to pay that holiday pay again, because that's what the Holidays Act says must happen. So I'd strongly discourage the use of casual employment agreements if the employment relationship is not truly casual in nature. That then brings us to trial periods, and it is important to remember that from the time when trial periods were first introduced as a tool for employers to use, the courts have very strictly interpreted the employer's rights to dismiss pursuant to a 90-day trial period. They must be used precisely, and you must comply with several obligations if trial periods are to be enforceable and valid. For example, the trial period clause must be contained within the intended employment agreement that you provide to an employee, and that clause within the employment agreement must confirm that the trial period will not exceed 90 days. The employment agreement must also contain detail about when the trial period starts, and it should be the day that the employment is due to commence. That is the employee's first day at work. The clause must explain to the employee what a trial period means, and it is helpful for a shorter notice period to be contained if the termination is pursuant to the trial period. We recommend 1 day's notice so that the employee can move on quickly if they're terminated, and we recommend including in your trial period provision that the employee will be placed on garden leave for the duration of the 1 day notice period. As I've said before, the existence of a 90-day trial period must be referred to in the letter of offer made to the employee, and other things that the employee must be told about is that they are entitled to and be given a reasonable opportunity to seek independent advice about the trial period and the employment agreement. And the final thing is that the employee must be a new employee. They cannot be an existing employee. Otherwise, the trial period provision will be held to be unenforceable. I thought I might just delve into a couple of cases a little bit further to give you some insight as to how the courts are interpreting these cases. The first is quite an old case of the Employment Court now, which is 15 years old, which is Smith and Stokes Valley Pharmacy. And in that case, a new purchaser came to purchase the pharmacy from the vendor. After the employees, the purchase occurred, the proposed new employer transferred everybody across, and after the transfer occurred, Stokes Valley Pharmacy provided all of the employees with written employment agreement. What the court held was that Ms. Smith, who was a former employee of the old vendor, but had not signed a new employment agreement before she commenced employment with Stokes Valley Pharmacy, was not a new employee at the time that she entered into her employment agreement. Because she was not a new employee, then the court interpreted the provisions of the Employment Relations Act very strictly and said that trial period clauses can only apply to new employees. Ms. Smith was not a new employee. She had been dismissed in reliance on the trial period provision, and that dismissal was therefore unlawful. As you can see, that's a fairly strict interpretation of the Act. In another case involving Talbot Agriculture and weight, the court found that the trial period also extends to a situation where the intended employee undertakes a work assessment to test their ability before they commence work. In this case, the employer asked the employee to conduct a work assessment prior to being offered the job. So the employee undertook a 2-day work assessment and was subsequently offered the job with an employment agreement that contained a trial period. The employee was subsequently dismissed in reliance on the trial period provision, and they successfully challenged the validity of the clause on the basis that they had already started working for the employer, and that was at a time when he was not aware of the trial period because he hadn't been offered or signed his employment agreement. Essentially, the court has said that a trial period cannot lawfully exist if there's already been an opportunity for the employer to assess the employee's suitability for work. So we say a key takeaway for employers in this area is to ensure that employees have signed their employment agreements at least a few days before coming onto the farm. There is another case that I can think of involving a farm worker who was offered a job, came to work early in the morning. The first task that the employee was required to undertake was to sign their employment agreement. It contained a trial period clause. The employee was subsequently dismissed in reliance on that trial period clause, and the court said, no, that's not a valid or enforceable trial period clause because the employee had already started work that morning. Therefore, they were not a new employee. Another area that can cause significant difficulties is with availability provisions. Dairy farming is not a 9-to-5 job, and it will require sometimes that employees work outside of their normal hours. And an obvious example of that is during calving, or if any issues happen that require additional hours for people to work. In order to compel an employee to come to work in the first instance, people must have agreed hours of work. Agreed hours of work include guaranteed hours of work. Typically that would be 40 hours per week. You must specify the days of the week on which that work is to be performed. Typically that would be Monday to Sunday, both days inclusive. It must contain reference to the span of hours within which that work is typically performed. That can vary, but it might, for example, be between 4 a.m. and 6 p.m. And it must specify if there's any variability around those 3 factors that I've just described. And typically that would be variability because people would typically roster staff on maybe a 4-on-2 off, maybe a 4-on-4 off, whatever it might be. But you have to make that clear in your hours of work clause for your agreed hours of work. If then you want people to work outside of those agreed hours, then you must have an availability provision contained within the employment agreement. And In order to require those additional hours through an availability provision, you must have genuine reason for the inclusion of the availability provision. And in a dairy farm, that is a genuine reason. Animals need care 24/7, and that means that staff need to be available, particularly during calving, to assist with any cows that need assistance with calving, but also to take the calves away for calf rearing, and then drafting off the calved cows for the purposes of milking. When considering the enforceability of an availability provision, the court will also look at whether or not the number of hours for which an employee is required to be available is reasonable. The court will look at the proportion of hours worked compared to the proportion of hours for which an employee is required to be available. They will look at the nature of any restrictions resulting from the availability provision, including, for example, whether or not any employee is free in their own time, but whilst being available to consume alcohol. For example, whether they must not be any more than 30 minutes away from the workplace if they don't live on farm, or any other restrictions placed on the employee's freedom whilst they are required to be available. The court will look at what the current rate of pay is, and whether or not the employee is remunerated by way of hourly rate or salary. If the person is remunerated by way of salary, then a salary may, in certain circumstances, be deemed to include reasonable compensation for a person's availability. If, however, a person is remunerated by hourly rate, then the employee must, if the employer is wanting to require them to be available outside of their agreed hours, must pay them reasonable compensation for their availability. At present, it is unclear about what that might be, and there is a series of interesting cases on this area, but if it is salaried, it is important that you include a provision in your employment agreement that states that, or something along the lines of, both the employer and the employee agree that your salary reasonably compensates you for any additional hours worked outside of your normal working hours. Now, that will only be the case if the salary is not low. So, for example, if you divide the salary by the number of hours actually worked over the year, and the hours worked mean that the person is not at least being paid the adult minimum wage, then you must top up an employee in those weeks where the minimum wage has not been paid. So say, for example, someone's on a salary such as 60 odd thousand, and if you divide that by 40 hours, then that just works out at the same as or better than just the adult minimum wage, and then the person does, say a 12 or 14-hour day because of calving, then you will need to top them up for the shortfall as between what they've been paid and the meeting of the adult minimum wage for each and every hour worked. I think an interesting case in this area is an AFCO case. And in that case, Mr. Stewart, so the case is Stewart and AFCO New Zealand Limited. Mr. Stewart was a meat processor, and his employment agreement contained an availability provision which stated that he may be required to work extra hours during the week and on weekends as required by his employer, and that he must work those additional hours as required by the employer. Um, there was an availability provision in his employment agreement that said he must work that, those additional hours, but it did not include any compensation for that availability. The employer then later offered some compensation, but the offer was rejected by Mr. Stewart because he believed the level of compensation offered was insufficient. There was no further negotiation between Mr. Stewart and his employer, and Mr. Stewart continued to work additional hours outside of those contained in his agreed hours provision. He felt that there was an absolute expectation that he do that, and he subsequently brought several grievance claims in the Employment Relations Authority, including in respect of what he considered to be a non-compliant availability provision in his employment agreement. And Mr. Stewart successfully argued that the availability provision did not comply with the Act because it didn't provide him with sufficient compensation for his availability. But the authority also said that he'd not suffered an actual disadvantage because his employer had not tried to enforce the availability provision. There was also no evidence of disadvantage having been suffered. That determination of the Employment Relations Authority was appealed, and the sole issue on appeal before the Employment Court was whether Mr. Stewart had suffered any disadvantage because of the non-compliant availability provision. And the court found that Mr. Stewart had suffered disadvantage, and that disadvantage arose by the inclusion of a non-compliant availability provision in his employment agreement. And specifically, there was no value attributed to Mr. Stewart's availability, and the employer did not share the cost of Mr. Stewart making himself available. The key point from this decision is that non-compliant availability provisions can amount to a disadvantage, and there must be compensation given to the employee for making themselves available. And the underlying rationale of this is the same as that of the reasons for reform in this area, and that is that things like availability provisions materially constrain employees' ability to plan their life away from work. And that being so, people should be compensated for that. And this case offers some really helpful insights. And it says that, in particular, even where the employer hasn't enforced an availability provision as such, the court will still consider the nature of the employment relationship as well as how and why the additional work is offered and accepted. And the court said that even though AFCO didn't attempt to enforce the availability provision in that case, in practice, Mr. Stewart felt that he could not realistically decline additional work, and that was because his team was so small, and if he declined the additional work, that would have meant a lot of stress was placed on his co-workers. There was a power imbalance between the company and the employee, and those factors justifiably informed his reasonable belief that there was an absolute expectation that he must accept and perform the additional work. So I think that case makes it pretty clear that if you're going to have an availability provision, you need to engage in negotiations for the amount of compensation that you will pay an employee if you're going to expect them to be available to perform work outside of their agreed hours of work. Finally, the court in that case noted that a non-compliant availability provision won't automatically give rise to a personal grievance, and it will only do so where an employee has suffered disadvantage as a result of that non-compliant provision. Okay, moving on to personal grievance claims. One of the things that we notice a lot that people haven't done is to update their employment agreements to include the fact that sexual harassment grievances now have a 12-month time frame within which a person can bring a claim, whereas all other personal grievances must be raised within 90 days. Now, what the transitional provisions of the Act say is that if you haven't amended your employment agreement to refer to the 12-month period for sexual harassment claims, then they can be brought at any time when they come to the employee's attention. Another, excuse me, another thing we frequently see is that employment agreements don't contain a provision that has a plain language explanation for the services available for the resolution of employment relationship problems. Basically, how can an employee bring a personal grievance claim against you? If you don't have one of these claims, then that is referenced, one of these clauses, that is referenced in the Employment Relations Act as grounds for submitting a personal grievance out of time. So pretty important that you get those things sorted. As you probably are all aware, from the 1st of April, the adult minimum wage increased from $23.15 an hour to $23.50. So that applies to everyone who's over the age of 16, unless they are a starting out worker or a trainee. So the starting out minimum wage, which is now $18.80 an hour, that is for employees who are aged between 16 and 17 years old who haven't done 6 months continuous employment with their current employer, or who are aged between 18 and 19 years old, who have been paid a social security benefit for 6 months or more, and who haven't completed 6 months continuous employment with the employer. Then you've got the training minimum wage. And the training minimum wage applies to employees who are 20 years or older, where their employment agreement states that they have to do at least 60 credits a year of an industry training program to become qualified. I thought I would just talk about a decision of the Employment Relations Authority in Ferguson and B.W. Sylvester Limited, as well as Bruce Sylvester. So Mr. Ferguson was a farm worker, and as is the case, at least in our experience, he was paid a salary, as are most farm workers. But the salary needs to be more than the minimum, or at least at a minimum, the same as the minimum wage. And as I said before, during winter, employees can work long hours, but particularly during calving. And the net result is that that can bring their earnings down per hour to below the minimum wage. And as you can see, in the case of Mr. Ferguson, he worked on average 74 hours a week, which meant that he was paid only $9.09 an hour for each hour worked. And that meant that his employer was in breach of minimum standards. And he argued that not only should the company, but also Mr. Bruce Sylvester, who was the sole director and shareholder of the company, should be held liable for these breaches. The timesheets provided by Mr. Ferguson showed that he worked on average, as I said, 74 hours a week, but the applicable minimum wage at that time was $15.75. So Mr. Ferguson was in effect paid well below the minimum wage. He therefore claimed that he was owed arrears of wages as well as 2 weeks' notice of termination of employment because he left, and also all outstanding holiday pay. This decision was the most recent in a range of determinations by the authority where the authority finds in favour of the employee and orders the company to pay the lost wages as well as compensation for hurt and humiliation. But the company wasn't making the payments ordered. So Mr. Ferguson then pursued the director, Bruce Sylvester, personally, and he and the Employment Relations Authority because the company hadn't kept accurate wage and time records, hadn't paid time and a half or provided an alternative holiday for working on a public holiday, and didn't pay the minimum wage. And the authority held that the company was ordered to pay arrears of wages to Mr. Ferguson plus interest. The company failed to provide wage and time records, and it also found that Mr. Sylvester, in his capacity as a director, was a person involved in the breach, and therefore ordered that Mr. Sylvester had to personally pay the lost wages plus interest, and he was ordered to pay a contribution to costs in the sum of $1,000. So the point is that you must have appropriate wage and time records, including timesheets. All too frequently we see in a dairy farm context that people don't have their timesheets for their workers, and then it's impossible to defend claims like this. In summary, the kind of pitfalls we see is that frequently people will use federated farmers agreements, but they don't fill them out completely or leave blank spaces, and this ends up creating all sorts of ambiguity and unintended consequence. Often too, people will put their personal name as the employer instead of the company. That means that the employment relationship is with the individual personally, not with the entity, and you risk a personal liability for all the debts of the employment relationship. Frequently, the tenancy agreement portion of the federated farmers agreements aren't properly completed, and that often prevents employers from undertaking farmhouse inspections or recovering debts for damage to properties. Often rent is not properly defined, nor is the ability to deduct rent from wages paid. That creates lots of problems. We often see that the agreed hours of work aren't properly completed. That then prevents implication of an availability being implemented, and then often employees claim that they haven't been given their appropriate breaks. Frequently, availability provisions aren't completed, and people don't fill out what the compensation will be paid to the employee for that availability. Job descriptions aren't completed, and of relevance to trial periods, people often don't fill out the agreement until after work commences, meaning that a trial period is unenforceable. Moving now to understanding whether or not a person is a contractor or an employee. The starting point really is Section 6 of the Employment Relations Act, which defines what an employee is. And basically it says that an employee is anyone of any age employed by an employer to do work for any hire or reward. And It includes, as I said earlier in this webinar, a person intending to work. So someone who has received an offer of employment and an employment agreement, have signed the employment agreement, but their job has not started. The definition of employee will exclude a volunteer who doesn't expect to be rewarded for their work to be performed as a volunteer and actually receives no reward. But the minute that you start rewarding a volunteer for work performed, then you really risk the relationship being interpreted as employment. And a classic example of that is a case called Salad Bowl, and that was where a person agreed to undertake an unpaid trial in a store that made salads for lunch for customers. At the end of the day's trial, the employer took a $50 note out of the till and gave it to the person for their trial. The employment was subsequently not offered, and the employee claimed that because they had been given that money, then they had received a reward. They were not a volunteer. They were captured by the Section 6 definition. They were an employee, and the Employment Relations Authority agreed. So if you're going to have volunteers, be very careful not to give them any form of hire or reward. In deciding whether someone is an employee as opposed to a contractor, the court will look at the real nature of the relationship between the parties. And frequently, and it still happens, employers classify people as independent contractors so that they can avoid their rights under the Employment Relations Act and the Holidays Act. And the Employment Relations Act indicates that a person can actually apply for a declaration from the authority or the court that they are to be deemed an employee, notwithstanding that they may have signed a contract for services or a contractor agreement. And there's no definition of contractor in the Employment Relations Act, but case law has traditionally defined an independent contractor as being someone who's hired under a contract for service, whereas an employee is defined as a person who's employed under a contract of service. As I said before, the court will look at the true nature of the relationship, and there's a long-standing decision of the New Zealand Supreme Court in Bryson and 3 Foot 6, and Mr. Bryson was a model maker on the Lord of the Rings series, on the set for the filming of Lord of the Rings. And in this case, he claimed that notwithstanding that he had a contract for contract of service, he in reality was an employee. And the court said, you've really got to look at all relevant matters, including what did the written or oral terms of the contract say, because frequently they will give an indication of the parties' common intention. Any divergence from those written terms in practical reality. Look at the way in which the parties have actually behaved in implementing their contract. What, if any, are the features of control and integration, and whether the contracted person has been effectively working on their own account, or whether they are entirely controlled by the principal and fully integrated into the business of the employer. And they also look at industry practice. I frequently ask the question, does the person derive income from other sources? And if the answer is no, then it's almost invariably going to be the case that the person is an employee, not a contractor. The control, the main tests are the control test, the integration test, and the fundamental test. The control test is all about the level of control that the principal has over the worker, and whether they're controlled as to start and finish times, their hours of work, and so on. And integration is the extent to which the contractor does everything on their own account or is fully reliant on the employer for invoicing and so on. And then lastly, there is the fundamental test. And that's, for example, whether they are paid wages directly or whether they are registered for GST, render their own invoices, earn over $60,000 and so on. So it's important from a rural perspective to think really carefully about this, particularly in the relief milking space, where often relief milkers will ask to be engaged as a contractor when in reality they are an employee. And that's, if you get that wrong, there are problems. And the problems are that you will have to likely pay holiday pay, you might fall foul of the minimum wage entitlements, you'll have sick leave obligations, you probably will need to have paid KiwiSaver contributions, PAYE will need to have been paid, and you may face penalties and a personal grievance claim in the Employment Relations Authority. And in a really good case that explained all of this was a case involving a Mr. Barry and CI Builders Limited. And Mr. Barry had worked for CI Builders for 3 years. And he claimed that he was an employee. And the company said, no, he's an independent contractor. And the court was asked to resolve the issue. There wasn't a written agreement between the parties. There was a verbal one. And it did suggest that it was intended that he was an independent contractor, but the court held that having assessed a number of factors and the weight of all of those, a considerable number of those factors pointed to the fact that the real nature of the relationship for Mr. Barry with CI Builders Limited was that he was an employee. So the company exercised detailed control over the way he performed his work. He worked under the strict direction and control of the owner or the relevant site manager. There was nothing to differentiate him from any of the other workers. There was no while there was no express prohibition on him working anywhere else or for others, that was unrealistic because he worked on average 40 hours a week continuously for 3 hours for the building company. He wasn't able to subcontract or delegate his work. He didn't invoice the company and he received wages. He had a tool belt, which is common for employees in the industry, but he didn't supply most of his own tools. He bore no risk in terms of if there was no work available, he was still paid by the company. And the company even applied for a wage subsidy for him during lockdown. So the court found with significant ease that he was an employee and not a contractor. So a couple of tips there. In terms of safely using contractors, they need to be able to work for other people. They need to be able to determine when they work for you. They've got to invoice for their work. They don't get any minimum entitlements like sick leave, annual leave, or KiwiSaver. They use their own tool. Oh, beg your pardon. They use their own tools and materials. They engage. You engage them through a company, not as an individual. They can delegate out their work and they handle their own tax arrangements. Right, service tenancy agreements. A service tenancy arrangement is quite different to a normal residential tenancy. And if an employee is working and living on the farm, key things to keep in mind are that they must have a service tenancy. It needs to be written and it can sometimes be part of the employment contract. In fact, that's what we frequently do. And if you've got it in writing, it makes it so much simpler to evict a tenant in the event of termination of the employment than it is under a normal residential tenancy. So it's important to make sure that you're clear about who the landlord is, that you are very clear about the standard of the housing. So you've still got to comply with the requirements of the Residential Tenancies Act, including having appropriate working smoke alarms, meeting the health and safety obligations, meeting the healthy home standards, and so on. And you've also got an obligation under the Health and Safety at Work Act to protect on-farm accommodation inhabitants from health and safety hazards and risks. And a lot of employers tend to fall into the trap of never conducting inspections on farm properties, but you've got to do that. And we thoroughly recommend doing it at the beginning of employment and taking lots of photographs of everything so that you've got a clear record of the quality of the property at the time before the employee enters the property, and that at the same time you identify any hazards or potential hazards, and then do regular inspections during the tenancy, and we say at least a minimum of 2 to 3 times a year, making sure that you give your 48 hours notice before you do that. Under the Residential Tenancies Act, you need to be aware that rent does not need to be payable for a service tenancy to exist. There are lots of special rules covering payment of rent, and they relate to notice, for example, with notice periods for a service tenancy, the notice period is significantly shorter at 14 days than what it is under a normal residential tenancy. In terms of deducting rent, in order for you to deduct rent from wages payable, it needs to be documented, preferably in both the employment agreement and the service tenancy agreement. And you need to have a deductions policy in your employment agreement so that if, for any reason, the employee is not working but remaining in the tenancy, so for example, if the employee experiences long-term sick leave but doesn't resign, then you need to have a mechanism for dealing with that. As I've said before also, your service tenancy should also be clear about the terms associated with ending a service tenancy. And typically the Residential Tenancies Act requires a notice period for a servant's tenancy to be at least 14 days. And then you should be looking to try and align the notice period in the service tenancy with the notice period in the employment agreement. So it's pretty important to give some thought to those considerations. A service tenancy usually lasts as long as the tenant's employment. And often the notice period for a service tenancy is different to other tenancies, or indeed it can be different to the notice period in the employment relationship. If the tenant wishes to end the tenancy before their employment ends, then they've got to give the standard notice required for ending a tenancy. So that means at least 21 days written notice, unless you agree otherwise in your employment agreement. You can't end the tenancy before the tenant's employment comes to an end, or give less than 14 days notice as a landlord unless you believe on reasonable grounds that the tenant will substantially damage the premises of the tenant if the tenant's allowed therefore to remain for 14 days. I've only been able to successfully prove that once, and that was where the employee was having bonfires on a frequent basis on the front lawn outside the tenancy, and the fuel for the bonfire came from within the property. So you can imagine that was pretty alarming to the landlord. You need to, another ground you can terminate is if you need to have a replacement employee appointed within less than 14 days and there's no other suitable accommodation to put that person into, then you can terminate early. But employers have got to have reasonable grounds to believe, as I said before, that the tenant will damage that property, and it's got to be things like making threats or telling others that they intend to damage the property. You can't just rely on empty threats or supposition. There is a really high threshold for early termination, and I guess what I suppose we need to be mindful of is that it means that that the tenant could be both without a job and a home. So that's why that threshold is high. In terms of obligations on a landlord, there's a provision in the Residential Tenancies Act that says between 1 July 21 and 1 July 25, all private rentals must comply with the Healthy Home Standard within certain timeframes, depending on whether it's a new tenancy or whether it's a renewal. And some private rentals may have additional time to comply with these, with the heating standards, for example, but it depends on whether the property uses the new heating formula to calculate the required heating capacity for the main living room. If you rent out an unlawful property, you're breaching your obligations, and you could be ordered by the Tenancy Tribunal to repay rent or other amounts such as compensation or penalties to the tenant. So it's really important for landlords and tenants to keep up to date accurate receipts and records related to the tenancy, because they can help clear up any issues that might arise. And I come back to my point that I said before about ensuring that you take very good photographs of the tenancy and the grounds prior to the tenancy commencing, and that you undertake regular reviews to ensure that the property is being kept to a standard that you as a landlord might expect. If all of the requirements for rental deductions are met, then you are able to deduct the market value of the accommodation from the employees, from the pay before the employee receives it. And that prevents unnecessary changing of money between the parties. And it means that the value of the accommodation forms part of the employee's total remuneration. It's therefore really important for tax purposes to ensure that the employee is being fairly compensated by identifying the amount of the remuneration and separately identifying the market value of the accommodation, and ensuring that the salary itself at least meets all of the minimum entitlements that I've previously described. And market rent is defined as what a willing landlord might reasonably expect to receive and a willing tenant may reasonably expect to pay for the tenancy in comparison with rent levels for similar types and sizes of tenancies in the same location. And we think it's always prudent to get a full appraisal done of your rental property to ensure that the market rate, that the rent you're charging meets the market rate. Right, on the final stretch is some immigration points. What we are seeing is that there's definitely faster processing of job check applications, as well as accredited work visa applications where they are decision ready. There's much stricter processing of job check applications and stricter penalties for breaches of visas, including some deportation. There's a lot of interest from migrants wanting to relocate to New Zealand, and there were more than 12.8 million movements in the New Zealand border in 2024. There has been delayed processing of accreditation where there are allegations of migrant exploitation, and also delays where there's been an incorrect understanding of a policy. There are a lot of changes ahead for 2025. And the government is intending to reduce the financial burden on businesses by making some changes to the accredited employer work visas, and they have taken effect or will do so sometime this year. So there are things like transitioning the median wage rate to the market rate, removing the requirement to complete Employment New Zealand modules, changing declarations for job checks, looking at high-risk employers, declining incomplete applications, looking at the maximum period of stay, looking at labour hire accreditation, minimum skills thresholds, and interim visa changes. They're also looking at increasing some visa duration, working remotely via the visitor visa, which you've probably heard about, the digital nomads, looking at seasonal workers, looking at greater rights for those on interim visas, moving from ANSCO, to the Australian New Zealand Standard Classification of occupations, to NOL, and looking more closely at the active Investor Plus visa. So that brings us to an end, and just letting you know some of the things that we offer. So we can give training on all of the immigration changes and compliance, and that would include an overview of New Zealand's immigration system and so on. Alice, over to you for any questions.
Thanks, Janet. No questions at the moment.
Okay, well, I think that gets us to conclude bang on time. Just one other note of how we can help. We do offer lots of support with the things on the screen, and we can offer a health and safety toolkit for a fixed price of $2,500 plus GST. So if we can help you with that, we'd love to. Thank you very much for attending our webinar today, and we can make a copy of this available to you as it has been recorded. Thank you very much, and goodbye.